lines of communication and cooperation between the judiciary and the legislature to uphold the democratic values and institutions that underpin our society. 2, state capture recommendations. The State Capture Commission submitted its final report to the President, who then tabled it to Parliament on the 23rd of October 2022. The Commission made 16 recommendations on Parliament's role, in addition to 3 recommendations relating to legislation and the work of the Committee on Ethics and Members' Interests. Numerous recommendations also concerned state departments and other entities. Then, under Parliament's implementation of the recommendations, in response to the Commission's recommendations, we developed a comprehensive implementation plan structured around 4 key focus areas, namely parliamentary oversight and accountability, parliamentary oversight of the Executive's response plan, monitoring of Parliament's implementation plan, and parliamentary reforms to strengthen Parliament's constitutional mandate. The implementation plan was referred to the relevant structures for implementation on the 31st of January 2023. Thus far, of the 19 recommendations relating specifically to the work of Parliament, 11 have been implemented and 8 are underway. As part of the implementation plan, at least 22 relevant parliamentary committees have been assigned to oversee executive action regarding the Commission's recommendations. These committees are required to provide quarterly reports on oversight matters related to the implementations of the Commission's recommendations. Under recommended legislative reforms, Parliament acknowledges the significance of legislative reforms suggested by the State Capture Commission. Work is underway to address these recommendations, and the Rules Committee has already reached conclusive positions on certain matters. Parliament has taken note of the Commission's recommendation to consider passing electoral reforms enabling a constituency-based electoral system alongside the existing proportional representative system. The recently enacted Electoral Amendment Act of 2023 establishes the Electoral Reform Consultation Panel, which will consult and make recommendations on potential electoral systems reforms. Regarding the Commission's recommendation to enact legislation protecting members of Parliament from losing their party membership and seats, Parliament affirms that the Constitution and the Powers and Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004 already provide powers and protection to members in the exercise of their functions. Therefore, no new legislative interventions are required in this regard. The Commission also recommended amending the Intelligence Services Oversight Act to ensure that outgoing Joint Standing Committee on Intelligence of Parliament reports to Parliament and provides an account of its work conducted during the previous 5-year term. After careful consideration, the Joint Standing Committee on Intelligence concluded that no amendments to current legislation are necessary, as the existing law already addresses the Commission's concern. To ensure consistent and regular reporting, the committee's support has been reinforced with requisite administrative capacity. The Commission emphasized that weaknesses in parliamentary oversight and executive accountability have contributed to corruption and maladministration over time. On this basis, the Commission recommended considering the principle of a mandatory accountability through an Act of Parliament to enhance oversight over the executive and its internal procedures. Parliament conducted research on international practices in 12 countries to evaluate comparable laws, including a mandatory accountability. The Rules Committee concluded that while certain legal reforms relating to parliamentary procedures advocated by the Commission may not be desirable at present, they could be considered in the future if necessary. In the meantime, the Rules Committee has agreed, which I chair, has agreed on parameters for guidelines to regulate relevant processes. Now, under strengthening of parliamentary oversight and executive accountability, Parliament acknowledges the importance of sufficient funding for effective oversight, particularly for committees. Despite current budgetary constraints, Parliament is actively engaging with the National Treasury to secure additional resources that align with its constitutional mandate. Parliament is also actively addressing the Commission's recommendation to establish an oversight and advisory section within Parliament, which will provide necessary technical support for committees. To enhance committee oversight capabilities over the executive, Parliament has committed to ensuring adequate funds. Additionally, Parliament has enhanced the scale and skills of research and technical assistance available to the portfolio committees. Critical positions, including content advisors, legal advisors, and researchers, have been filled, whilst recruitment is underway for the remaining positions. And I want to emphasize that this all happened at the insistence of the report of the Commission. This capacity will fulfill this recommendation in the interim, while the envisioned oversight and advisory section undergoes consideration as part of the parliamentary realignment process set to conclude before the end of the current financial year. The Commission also highlighted instances where the executive fails to take account of parliamentary resolutions and report on them. Parliament acknowledges that challenges with resolution implementation sometimes originate within Parliament itself, including monitoring and the technical nature of the resolutions. To address these challenges, the Rules Committee recommended that recommendations arising from the committee activities be substantiated, specific, include timeframes, and relate to matters within the purview of the Assembly. Additionally, the Speaker will maintain a record of resolutions and, in case of delays, liaise with the leader of government business. The Speaker will report to the Rules Committee of the National Assembly twice a year on the status of the responses. To ensure appropriate executive accountability for processing resolutions, Parliament will enforce measures requiring the executive to report to Parliament on measures emanating from resolutions within the prescribed timeframes, or if no timeframes have been given within 60 days. The leader of government business will submit an annual report to the Speaker on the status of executive compliance with resolutions, which will then be included in the Speaker's report to the Rules Committee. The Commission also raised concerns about instances where ministers and other others failed to appear before Parliament without adequate cause. The Rules Committee notes that the powers, privileges, and immunities of Parliament and Provincial Legislatures Act 4 of 2004 already considers such actions as contempt of Parliament, making, therefore, them offences under the Act. However, invoking the Act has always been seen as the last resort, and cooperation between Parliament and the Executive is preferred before pursuing sanctions. The Rules Committee emphasizes that measures have been implemented to facilitate executive attendance, and existing legislation has been successfully utilized, as demonstrated recently by the minister summoned to appear before a committee in 2022. Under merit-based appointments in state institutions, regarding the selection of office bearers for state institutions or organs, the Commission emphasized the importance on high-level public scrutiny and merit-based appointments. Parliament acknowledged that laws and best practices concerning the selection of certain office bearers are already in place, ensuring merit-based appointments. To enhance the integrity of these appointments, Parliament will develop guidelines that incorporate relevant laws and best practices. Under oversight over presidency, Parliament has considered establishing a committee to oversee aspects of the presidency not currently supervised by existing structures, as recommended by the Commission. The Parliamentary Budget Office conducted research to identify aspects of the presidency budget not currently subjected to parliamentary scrutiny. The Parliamentary Budget Office concluded that Parliament should strengthen its oversight over the presidency and recommend further research. The Rules Committee agreed that the PBO's desktop research should be supplemented with a fact-finding visit to explore international best practices on the matter. The comprehensive approach will establish a solid foundation for the 7th Parliament, and the findings of the fact-finding mission, which took place recently, will be processed. We can talk to those matters, ladies and gentlemen of the media, when you seek clarity. Under consideration of committee chairpersons, Commission recommended that parliamentary oversight may be better served if more chairpersons were elected from minority parties. Parliament affirms the authority of the Assembly to determine committee chairpersons and internal arrangements, proceedings, and procedures. In this regard, it will not interfere with democratic decision-making processes within the committee, which include election of chairpersons. However, Parliament will ensure promotion of fair and representative selection of committee chairpersons. Under MPs fingered in the Commission report, during the Commission's proceedings, several members of Parliament were implicated. The presiding officers referred 6 members of Parliament to the Joint Committee on Ethics and Members' Interest, and an additional 6 were sent by an external entity. Now, to date, the committee has found against 3 MPs, cleared 5, whilst 2 are still under consideration. At least 2 MPs have since resigned from Parliament and therefore fall outside of the scope of the application of the Ethics Code. The committee will give a comprehensive report of this work in line with quarterly reporting arrangements. Under Executive Implementations Plan, With respect to the Executive's implementation plan submitted by the President to Parliament, Parliament acknowledges that the President's response to the Commission's recommendations includes the implementation of specified recommendations, outlines the implementation of aspects of the recommendations, and identifies areas for further consideration. Some responses provide reasons for not implementing specific recommendations, including instances where they overlap with ongoing government work. The majority of the Commission's recommendations are directed towards law enforcement agencies for investigation and potential prosecution. Although these agencies operate within the executive arm of the state, they are constitutionally and legislatively mandated to exercise their responsibilities independently. To ensure the desired outcomes of these recommendations, the designated committees and structures of Parliament must provide quarterly reports to the Programme Committee. Committees are reporting on the progress in monitoring and overseeing the implementation of the Commission's recommendations. Conclusion. The presiding officers of Parliament commend the constructive meeting with the Chief Justice Raymond Zondo, and we expressed our gratitude for the frank discussions held during that engagement. Parliament assures the public that it is dedicated to implementing the Commission's recommendations diligently and transparently, ensuring accountability and safeguarding the integrity of our democratic institutions. I thank you, ladies and gentlemen.
Thank you very much, Madam Speaker. Colleagues, please distribute both the decision matrix as well as the statement. But in the meantime, we will start with taking questions from the floor of the physical media briefing, and thereafter we will go to virtual. So there will be somebody who is manning the virtual part so that the questions can be read out for the members of the panel. Just indicate your name and your company and shoot, starting from the front, and then followed by you will be the second, and then ma'am, the second row, you will be the third, and then you will be the fourth. Is there any other hand that I did not? You are the first, so any other hand that I have not recognized? Okay, so there are four hands. All right, in that order.
Thank you very much, Mloto. My name is Zianda Ngobo. I work for Newsroom Africa. I've got a series of questions. The first is, I'd like to know, excuse me, prior to yesterday's engagement, was there any kind of communication before the Chief Justice, before the Chief Justice made those remarks in the form of a letter, in the form of any other meeting, or was Parliament and you as presiding officers taken aback by those statements, given what you've just outlined, Madam Speaker? The second thing is, you did table that report on the 31st of January this year, and you've just outlined the implementation. When it comes to the Oversight Committee in the Presidency, so you said it's not going to be desktop research, you're going to move it towards a on-site fact-finding visit. How long is that going to take? Is there a possibility that after this research, just for clarity's sake, that you could come back and say that the Presidency does not need an Oversight Committee? Or are you saying you're looking into establishing a committee for the Presidency, but you're setting up what exactly the modalities of it are going to be? And then you refer to, during one of the recommendations, that you didn't necessarily have, the technical and other resources that you needed to be able to implement. Is that also the reason why you weren't able to implement the Electoral Amendment Act? What is it that was stopping you from that aspect, that you've even had to ask for an extension? Yeah, let me leave it there for now. Thank you.
Number 2.
I think it's me. It's gone. Thank you, Moloto. It's Kanima.
No, it was him actually, because I was taking row by row. So don't forget your allocated numbers. You will be the third.
Good day, guys. Kosnati Shazi from Power FM News. I'll be very brief. My question is regarding the attitude of Parliament with the meeting with the Chief Justice. So the question I want to pose is Parliament immune to public scrutiny? The meeting you guys held with the Chief Justice yesterday, did you guys see it as an indictment on Parliament failing to execute its duties, or did you guys actually see it as constructive criticism? You know, we are often labeled the fourth estate, and our job is to hold government, public officials accountable for their actions. So I just wanted to find out the tone of Parliament. Did you deem this as an indictment on yourselves, or was it constructive criticism? Ngiyabonga.
Yes.
Thank you, Malota. It's Kanima Panga from SABC News. I just want to find out from Parliament, appreciating that was a private engagement yesterday with the Chief Justice. Are you able to take us into confidence in those discussions if he mentioned what he did see, or rather did not see, from Parliament that informed the statement that he made? And then the second question is that based on what we have seen with some of these controversial cases that we are seeing in the country, is Parliament not of the view that it would be beneficial to have a commission that's established outside of it to monitor should you fail, not assuming that you would, but should there be challenges in holding those to account, then you have that extra support to achieve that. Thank you.
Thank you. And then the last hand, the fourth. We're the fourth here.
Thank you very much. My name is Muluku Muloto from ENCA. I just want to know, well, firstly, after this meeting with the Chief Justice, do you still believe his remarks that he made publicly are still inappropriate, and you believe that they are encroaching onto your work as a separate arm of the state? But also, in your engagement with him, did he apologize? Did you want him to retract those remarks? But regarding the MPs that have been referred to the Joint Committee on Ethics and Members' Interests, you mentioned the number there. Does that include members of Parliament who are in the executives, either as cabinet ministers or deputy ministers? Lastly, do you get a sense that perhaps more so because some of the recommendations you are rejecting, really, for instance, where the Chief Justice is calling on the specific law, you are saying that the current laws are enough, although in some instances you want to augment one way or the other. Considering that the Chief Justice, as head of the judiciary, his responsibility is to interpret the laws, do you not think that for the recommendations that he made, he did see some loopholes there? And as somebody who is trained and is capable of interpreting these laws, that he understood that they are not effective, as much as it is your responsibility as the legislature to make these laws, but ultimately they must pass the constitutional master. Do you not get a sense that perhaps by just ignoring some of them, believing that the existing laws are sufficient, perhaps you might be missing an opportunity there to remedy this whole situation?
Okay. Thank you very much, Moloko Moloto. Oh, you were the fifth? Oh, I didn't see that there were five people. I'm sure the public can see that there is difference. We are two different human beings because I get attacked all the time on social media for the stories that you are writing or you are reporting. People thinking that I'm you. Okay, I think we've got the fifth hand and the sixth hand physical in the physical media briefing. Okay.
Good morning or good afternoon, everyone. Zoleka Kotashe from SABC News. I know Moloko asked one of my questions, but I wanted to know, part of the recommendations made or some of the concerns in the report was the majority of the governing party to use their majority in parliament to prevent certain previous motions of no confidence in former President Jacob Zuma. Now we've seen with the former Chief Justice report into Phala Phala, how that was again the case. What has Parliament done? That is a recommendation by Parliament and its failure to hold the executive accountable. But also saying that the governing party uses its majority in Parliament to evade any sense of responsibility. And we've seen with the Phala Phala report as well. What is your response to this? How does Parliament intend to remedy something like that? Thank you.
Thank you very much, Zoleka. I'm sure you are aware that it was more than just the majority party that voted against the Phala Phala report.
Yes.
Okay. The last hand, the sixth one.
This is Kinelo Huma. I work for Kaya News. Following yesterday's meeting, Parliament and the Chief Justice have decided to now have regular meetings to give updates about issues of mutual interest. I wanted to find out, does this decision come after the fact that the Chief Justice had spoken only in public? Shouldn't this have been something that was already planned, considering that there was this issue before Parliament, that was the report, and that discussions should have happened? Is this only because he went publicly and spoke, and this is probably a response to that? Thank you.
Thank you very much, Kenele. Now, time for responses. Honorable Chairperson of the NCOP.
Thank you very much, Moloto. I want to start off by saying that our attitudes towards the meeting was informed by the need to explore issues, raise issues, look at them, and isolate matters that we thought would be for discussion and engagement. What was really dominating factor in our thinking was the need to find one another and to arrive at search for and arrive at appropriate solutions. Now, on the question of research and empowering of committees, one can look at the report. It speaks for itself. And this matter is a matter that is that Parliament has been seized with over many years. And our sense is that we are making progress in ensuring that committee members of Parliament are properly empowered. Not that there are no weaknesses, but in an ongoing way, the issue is being addressed. On the Electoral Amendment Act, the Act, as we know, has now been passed by Parliament. There are those who are challenging the law as it stands at the moment, but our trust is really that, and we remain optimistic that the new law will enable the elections to take place in 2024, and that indeed the new electoral system will only be considered after the elections. And we're very confident that this is what is going to happen in the coming period. So we have the view that members of the public have a right to question the law as it stands, but we don't think that this process must be managed in a way that seeks to ensure that the elections aren't duly delayed, because there are many other negative implications that one can associate that kind of idea with. But we're confident that things will go well, that elections will take place, that the new electoral system will be considered after the elections, and that many of the challenges that are there will be addressed thereafter. Is Parliament immune to public criticism? No. Like any other institution, Parliament can and do get criticized from time to time. Yes. So we're not immune to public criticism. So Parliament can be criticized. Need for an external body to hold Parliament accountable. I don't think I understood that question that well. But my own response would basically be that Parliament is accountable to all of South Africa and South Africans. And therefore, in an ongoing way, we do experience people raising issues, criticizing Parliament for this or the other, and so on. As I've said before, Parliament is not immune to criticism. And the civil society organizations do engage Parliament in a variety of ways, and this indeed is an ongoing practice, and we're looking forward to it being strengthened as we move into the future. But there's no single body that can claim a preserve of holding Parliament alone, it alone. It can be. Did the Chief Justice apologize? That was not the spirit of the meeting. The meeting sought to identify issues, discuss them, and move in the direction of finding appropriate solutions. The last question, Honourable Speaker, is majority rule. Well, my understanding is that is democracy. Those who win elections have got to have a responsibility to ensure that governing happens, and it happens in keeping with how the majority of the people have voted. This thing of being negative against the majority, this fear of majority and so on, I don't think leads us in the right kind of direction. Let's apply democracy as it applies anywhere else in the world. So there's no need to fear the majority and to be negative against the concept of majority rule. That would be my short response. Thank you very much.
Thank you very much, Chairperson of the session, as you are presiding. Speaker, thank you very much. I think there's not many questions, but it's very important questions that have been asked. And I want to start by where the Chairperson have just ended, and it is the issue of parties and majority. Parliament is made up of parties that have been elected into Parliament. And parties, when they are voting with their party's mandate, it doesn't necessarily mean that Parliament is the one that should take responsibility for how parties exercise their democratic right within the sphere of Parliament or in the space of Parliament. I think that should be, we should respond to that, because it can come to a point that we question the mere fact of the electoral mandate, because the electorate give a mandate to the parties, and parties have got the responsibility, or members have got the responsibility to exercise the mandate of their party. That is the first one that I wanted to respond to. Secondly, there were many questions asked about the engagement of Parliament in the Chief Justice. Chief Justice, or there was a commission that was appointed for a certain time to exercise a certain responsibility or a task. It reported to the President, and there was some of the issues that actually was for Parliament to deal with. Now, there is the relationship of the three arms of state is particularly spelled out in Chapter 3 of the Constitution under cooperative governance, particularly Article 40 and 41 of that chapter. And that means that there should be mutual respect, and there should be mutual cooperation, and there should be mutual support for one another. Bringing me to the response to say, if there was anything that the Chief Justice felt that Parliament have not complied in terms of his recommendations, it should have been the first point of call, should have been the Speaker and the Chairperson or the Executive Authority of Parliament. I think I'm responding to the fact that there was a question that asked, was there engagement before, or do we feel as Parliament that it was not constructive? It's not about what was said per se. It's about how we deal with one another within the space that is provided for within the Constitution. That is the issue. Lastly, I want to say there is no rejection of any of the recommendations, because recommendations is what it says, unless I don't understand English so well coming from Uppington. But a recommendation is something that actually recommends so that we can look into what is existing and where we need to strengthen or what we need to do more. And where Parliament is responding to say, but there is sufficiently provided for within the framework, legislatively, rules and otherwise, within Parliament. That means that we are not rejecting the recommendation. It's just that already there is enough provision for the specific issues that was dealt with within the recommendation. Because otherwise we will say Parliament rejected, and it is very strong language, and we have no right to reject a commission or any recommendation, because any, even the Auditor General, it's after there was legislation, just made recommendations. But within the goodwill that is existing, or within the cooperative governance framework that is existing, Parliament have been making sure that we implement recommendations. And that is why we could see within that specific responsibility, if there is no necessity to over-legislate or to over provide for issues that is already within the framework that is provided for within our rules, within our legislative framework, etc. So I think, and there is one issue that I really want to raise, and excuse me for that, Speaker. I think Parliament is one of the most transparent bodies, more than any other body that is existing, because our committees, all our sessions, everything is open, it is broadcasted, and everyone has got the right to petition Parliament on any issue. So my experience since I came to Parliament nationally in 2019 is one of the most transparent bodies. And I'm sure we've got nothing to hide. And if there is anything that you feel that Parliament is not responsible on enough, you've got the right to petition, or you've got the right to send questions to ask us, and Parliament have the responsibility to make sure that we respond to everything. Thank you.
Thank you. Thank you very much. And thank you for the questions, ladies and gentlemen of the media, because it's important that we clarify one another on these matters. There's a question here which was raised, which was whether the statement by the CJ was to be expected, our reaction to it. And the answer is yes, of course, we were shocked. We did not expect it. That's the truth of the matter. There hadn't been some prior consultation as to what would come out of a lecture, if it was a memorial lecture by the CJ. Of course, the Parliament, of course, is subjected to public scrutiny all the time. However, the one reason why we decided that we should have an engagement with the CJ is that there's a difference between what you write, what you say, and what any other South African says about Parliament or about an arm of the state, which is the legislature. But it's something else when a head of an arm of the state, of that institution, the judiciary, raises a matter in the public arena about another arm of the state. You get my point? So it's not so much that you are beyond, as Parliament, we are beyond reproach. We do not want criticism. No, no. It is about a head of the judiciary, the Chief Justice of the Republic of South Africa, takes the floor and raises issues which he has never raised with the presiding officers of Parliament. Now, the state is made of 3 arms. South Africa is a constitutional democracy. We have these 3 arms of the state which collaborate, which cooperate, but once you pick up something that is likely to cause and give a picture to the South African public that there is no stability in the state. Because when that happens, it creates amongst yourselves and everybody an impression that these people are not talking. What's happening? These ones are undermining that one. What is this now? Is this the democracy we have? We have a stable democracy. And part of its foundations should be regular interactions between the heads of the 3 arms of the state. So when that statement came out, and of course there was reaction to the statement, but you must have observed that from the side of the presiding officer, the executive authority of parliament, we did not respond. Deliberately so. Because it can't be us who, in a public domain, in the streets, responding to a matter raised by the Chief Justice. We had a quick consultation and we said, we're not going to respond to this. At best, so that we needed to understand the context within which his remarks were made. So we had this interaction with the Chief Justice, and indeed, we do have an appreciation of the context within which the remarks were made. So sometimes so the answer is what I've said. It was a yes. I mean, we're shocked because the immediate thing the chairperson asked was, did you receive any request for a meeting? Is there something we are missing? And we asked the secretaries, STP, is there something we are missing? Is there something we've not done right? And we could not get it, and therefore, hence the need for clarity, but also to explore issues, to engage amongst ourselves so that we have an understanding. You can never have 3 arms of the state which do not work or collaborate with one another. So the essence of what we were trying to do there was to say, CJ, you've raised your issues. Let us understand the context within which you raise the issues. Allow me to go to that context because it has been raised by the SAPC. CJ says, Speaker Chairperson, there have been several motions of no confidence moved in Parliament against a head of state. Then he goes back and says, if I recall, there were 8 motions which were moved against a sitting head of state then. Okay? Remember, this was prior to the State Capture Commission. And so we listened, and he said those motions of no confidence could not succeed because of the majority of members of parliament who belong to a particular party. Obviously, colleagues, this is a democracy. It's a multi-party. We have 14 parties in parliament. So our response to that was, you are correct. And we actually know who he was referring to, which party he was referring to. But we said, CJ, you cannot then put it at the doorstep of Parliament and say Parliament has not followed its processes. And then we went on to say, following your report actually, if you look at Section 89 of the Constitution, which talks about a removal of a head of state, right? Following this commission, Parliament had to sit after 2018 and look and devise a rule, formulate a rule that would be used in the event there were to be this kind of situation we were confronted with at the time. That was done. We formulated the piece of the rule. And of course, following that, subsequently, this year or last year, there was another motion against a sitting president. And what did we do, colleagues? We went back to the rules which we had drawn after that experience of the 8 motions which the judge was referring to. And we reminded him that you can't say Parliament did nothing. We actually formulated this particular rule, which rules leads towards an impeachment of a head of state. However, there are certain things which must happen first. That is, one, you must have a substantive motion against the head of state. And once you have a substantive motion against the head of state, then Parliament puts together a panel. And that panel is the one which we had put together, which all of you are aware of, which was chaired by former Chief Justice Zondo. And the Chief Justice Zondo and his team worked behind the scenes. They did their work, and they presented a report to Parliament. Parliament did not hide the report. It was a transparent process. We gave you the report, and the report was tabled before the House of Assembly. And having tabled the report before the House, then the House voted on the report. Ne? The House voted on the report. And of course then, having voted on the report, the majority voted against the report. What is my point? My point is that you can't say nothing has been done by Parliament. We here, as the EAs, our conscience is very clear that we did everything to the latter, everything relevant to this section of our Constitution. Now, I then said to CJ, maybe CJ, as we conduct, as we do civic education, memorial lectures, and so on, the emphasis actually should be on political parties and civil society, that when you send your representatives to Parliament, at some point they'll be confronted with A, B, C, D, and E. But you can't, because the report was voted against by the majority in Parliament, you can't then say Parliament failed in its execution of its task. Ours as Parliament was to ensure that we put together systems that will do what is desirable, and if we don't win then, having done that, it is not us, it is the political parties which are sitting in Parliament. Then, of course, the CJ raised the matter of the majority. It's out of our hands, that one. There's majoritarian rule in South Africa. It's a democracy. It's absolutely nothing. It has nothing to do with us. So to raise an issue around the majority, that the majority exercised its majority, has nothing to do with the presiding officers of Parliament and has nothing to do with the processes of Parliament. Majority used its majority. And this is what we explained to the CJ. And I think he understood that. Now, you're asking whether he withdrew the remarks. Of course he wouldn't withdraw the remarks because he believes what he said is correct. But of course he had to understand, that is why we ended up with a discussion on majoritarian, democracy, and the rules of Parliament. That we have rules, we have everything, we have processes, and this is what we have been doing. We followed because we've learned from our past experiences. So an impression should not be created that Parliament has not learned from its previous experiences. No, no. Now, the chairperson have responded to the issue of the Electoral Amendment Act. I just want to, and I think these are some of the things the media should also be picking on. This is politics. There's something called politics. There's something called the law. Sometimes it can be very dangerous to venture into an area of politics because you end up being entangled in debates by politicians. And once you get entangled in debates and positions of politicians, you may actually find it difficult at the end of the day to adjudicate when there is a crisis amongst ourselves. I'm raising this because this Electoral Amendment Act is ready. But we know that right now it has been taken on review to the Constitutional Court because there are groupings which are unhappy with it. You see now, that's a tricky one. Because once you've commented on that Electoral Amendment Act and expressed your views, it makes it difficult tomorrow when this matter is presented before you to adjudicate on the matter. Because then we remind you that, but by the way, you have views on this matter and you've commented on the matter. So those are some of the, and I think that the spirit of the meeting which we had with the CJ was such, and I think he understood some of the issues we raised. There was no disagreement whatsoever. The other thing we emphasized, by the way, is that in the report itself, there is nowhere where it is stated that it is expected that we report back to the chief, the CJ as head of the commission about progress made in our work. Nowhere. There is nowhere. If we had a clause that says we have to go back and report, maybe we would have done that. So he wouldn't have known what work is being done in Parliament until such time he himself asks for information from those who are deployed to Parliament. Now, my brother from ENCA, you are saying we are literally rejecting the majority of the recommendations. No, actually. It's the opposite. And if you, or I think they'll give you a matrix which we are using. There's no truth to it, but what is happening is that you'll find that most of the recommendations are actually talking to what we are currently doing anyway. But what needs to be done is to enhance the manner in which we exercise or we implement the rules. So a lot of what came out here in the report are things which are there in the rules. Those who were there drafting the Constitution, I guess, and the rules had the foresight to appreciate that we may get to a point where we'll have these kinds of challenges. However, it is the speed with which we do things at times and how we do things. Not that it is not accommodated for in the rules. So if you look at that is why we're saying, in terms of the work, which recommendations which came to us, a lot has been done. And allow me to get to the issue of because we know we have a constitutional obligation to do these things anyway. Allow me to go to the issue of the Oversight Committee, because it has been raised over the Presidency. You know, what we did here is we requested our research team to do some work, just to do a desktop analysis of where this thing is, where we can find it, and what it is that we do. The report was presented to us. And when the report was presented to us, we found that, in fact, we don't have this animal called Oversight over Vote 1. But rather what we have in India, for instance, you have an overarching committee which monitors across the board. And then in Britain, you have what is called a liaison subcommittee, which liaison subcommittee has a responsibility to engage with the Prime Minister. So thrice a year, the Prime Minister appears before the liaison committee, and we are not even clear what kinds of issues are discussed between the liaison subcommittee and the Office of the Prime Minister. So after a long debate amongst ourselves in Parliament about whether to have an oversight committee or not, we decided, okay, let's have a small group from the Rules Committee, which is called the Review Subcommittee, to go to Britain and make sure that their visit coincides with the appearance of the Prime Minister before the subcommittee. And that's what we are currently doing. In other words, much as people are saying, you'll hear debates out there, people are saying, people don't want an oversight committee over the presidency. Others are saying, of course, yes, we don't want. So we said, let's find a middle ground. We have to exercise oversight. Let's have an appreciation of which areas require that kind of scrutiny by Parliament. And then we have this team. So the team, I think, is leaving on the 17th, I think, to appear, to be there, to observe and see, because anyway, our system is a Westminster system. So we're trying, I'm saying, ENCA, even on the meta-year committees, because there's a recommendation there, a recommendation which says the majority of committees in Parliament should be chaired by the opposition. That's what it says. The majority of committees should be chaired. Parliament has its own internal processes and procedures. Committees have their own internal processes where the committees come together and they decide as committee, by the way, I can't even interfere as the speaker there. Then they decide who they want as the chair of that committee. So this, what I think we do not want to appear to be defensive or to be in the offensive, but we are simply stating facts as they have been presented to us by the State Capture Commission and how we have since responded to those issues. But a suggestion that nothing is being done, and which the Chief Justice also yesterday did say that he didn't say nothing is being done, but he was foreseeing a situation where in the future we may slide back to the old tendencies of not following up on some of these matters. And as I said, we clarified the issue. I think the last issue I would like to address is, somebody said CJ interprets the law. That's the point. He's the ultimate in terms of the law. He's the Chief Justice of the Republic of South Africa. So whatever the CJ says is law. And whatever the CJ says, everybody here, in the public will say, yes, yeah, the CJ is correct, okay? And that is why we said we will not be opportunistic as the legislature and want to engage a CJ in the public domain. It wouldn't have helped us. It wouldn't have been good for our democracy. It's not healthy for a democracy. So he made his statement, and we decided quietly to seek audience with him, and we explained all of these things to the CJ. And I can attest to the fact that he really appreciated the meeting and actually clarified certain things like, well, I didn't say this one, I didn't say that one. But unfortunately, we've not been able to get the statement of the CJ so that we see the context within which some of these things were said. But commission work ended last year. And there's nowhere, I repeat, where it says, at the conclusion of this work, Parliament will have an obligation to then report progress made. No. So we are not adverse to public scrutiny at all. But it also depends on who does that scrutiny. who does that scrutiny and how is it done? And I think that's what has put us where we are now. So we're happy, Tina, with the meeting yesterday. We think it went very, very well. We believe that the discussions were with the CJ were very cordial, respectful. I mean, there was mutual respect, clearly. And I hope that we can avoid some of these things, because we do not want to send a message to South Africans that there may be instability in South Africa. There is no instability in this country. This is a very healthy democracy where there is vibrant engagement when it is necessary to do so, and therefore no impression should be created that there's instability in the country. The arms of the state, three arms of the state, work together. It is for that reason that the President Naye, after receiving his report, worked on a plan of action and submitted that plan of action in Parliament, because he knows that we then have to conduct oversight on the basis of what he has submitted to us. Lastly, with regards to law enforcement agencies, kaloku thina, we are not a law enforcement agency. And by the way, it was not even raised by the CJ Londole. It did not raise that. There are people who are law enforcement agencies that's under the arm of the executive and not under us. But of course, you know as well as I do that on a regular basis, the law enforcement agencies do appear before committees. They appear before the committees. They appear before the police. They appear before SCOPA to provide updates on work done by their forces. Thank you very much.
Thank you very much, Presiding Officers. Can we then give the opportunity, give the virtual platform an opportunity to ask questions, and then I hope that we will be able to wrap up after, unless there are other pressing questions. I see some hands now intimidating me at the front. But can we give the colleagues on the virtual platform an opportunity as well to ask questions before we give you a second bite? Are there any hands on the virtual platform? Which hands are there? Do you have a mic? Andisiwe,
on the platform, Chair.
Andisiwe, you are the first one on the virtual platform. How many hands do we have there?
Thank you.
Only one. Oh. Okay.
May I go?
Yes.
Hi, thank you so much, Muloto. Good afternoon, Presiding Officers. My name is Andisiwe Maginana. I write for the Sunday Times. Speaker, I just need, my first question is a question of clarity on the entanglement in politics. And I don't know if you gave this as an example when you spoke about the Chief Justice's previous comments on the Electoral Amendment Bill. I just want to check, did you raise this specific issue with him, or you were just giving it as an example to us where a judge gets involved in politics? And if you did raise the matter with him, what was his response? But also, is Parliament considering some sort of action, maybe to get him to recuse himself, saying that this matter is before the Constitutional Court, to get him to recuse himself when it is being dealt with by the court? My second question, Speaker, when the Chief Justice addressed this event last week, I think he was speaking more as the chairperson of the commission, and he was speaking on the progress that has been made since the work of the commission officially ended a year ago. So is it possible that there is not much blurring of the lines by a chief, by a head of the judiciary, but it's more, he was speaking more as someone who had chaired the commission, and he was responding to questions that are being asked about progress that has been made on the recommendations he made. I don't know if that is clear. And then lastly, Speaker, when Parliament requests some of its units to conduct research, or when you go on this when you go on these visits like overseas on these study tours, isn't that tantamount to second guessing the work of the Commission? If, for instance, the unit that did research found contrary to the Commission, how do you decide which carries more weight? How do you make a decision? Because you've got a commission that was very clear, especially on this oversight committee on the president and the presidency, because in the recommendations, the Chief Justice went into great detail about the importance of overseeing the president and the presidency. So if you